If you have seen posts saying the US has launched a new operation targeting South Indians, you are not alone. These claims are spreading fast, and they are scary because people worry about arrests, visa cancellations, or green card denials. Here is what I am going to do in this video. First, separate what we can verify from what we cannot confirm yet. Second, explain what a real enforcement drive usually looks like in plain English and which agencies actually do what. Third, give you a practical checklist you can use right now to reduce risk and avoid mistakes that can trigger problems even during routine enforcement. Here is the part most people miss. Even when a rumor is exaggerated, it can still point to a real trend, like more worksite visits, more travel questioning, or more requests for evidence. But a trend is not the same thing as a group being targeted by law. So let us slow this down and focus on what you can control. First, what do we actually know? As of now, based on the brief we have, we do not have an official public memo, named program, or confirmed announcement that says South Indians as a region are being targeted. When something like that is official, it is typically traceable to a government press release, a public statement, a court filing, or a written policy update. If the only evidence is social media posts, forwarded messages, or someone saying a friend was questioned, that is not confirmation. It is a signal to be cautious and to verify. So what can be true at the same time? 1. The U.S. can run enforcement operations focused on fraud patterns, document mills, fake job offers, or non-compliance in specific industries. 2. Because many Indians, including South Indians, are concentrated in certain industries and visa categories, it can feel like the community is being targeted even if the stated focus is a fraud or compliance pattern. And 3. Individual officers at different points in the system can ask tough questions that feel personal, even when the legal standard is supposed to be case-based. This is where people get denied or delayed, not because of where they are from, but because a small status mistake, an inconsistent document, or an employer compliance issue gets exposed during heightened scrutiny. Now, let us clarify the agencies, because a lot of confusion comes from mixing them up. USCIS is the benefits agency. They decide petitions like H-1B, L-1, O-1, I-140, I-130, adjustment of status, employment authorization, and so on. They can issue requests for evidence, notices of intent to deny, and they can schedule interviews. USCIS officers are not ICE agents, but USCIS can refer cases for fraud review or investigation when something looks inconsistent. ICE is primarily enforcement and investigations, including worksite enforcement and fraud investigations. ICE can also issue notices to appear in immigration court in some situations. CBP is border and ports of entry. CBP decides whether you can enter the U.S. at the airport or land border. CBP can refer you to secondary inspection, ask for documents, and in some cases cancel a visa or refuse admission based on what they find, depending on the facts. Here is the key. When people say operation, it could mean any one of these: an ICE fraud investigation, an ICE worksite action, a USCIS compliance push like more site visits, or a CBP trend of tougher questioning at airports. Those are very different experiences, and the right response depends on which one is actually happening. So, who could be affected if there really is a heightened enforcement drive? Think in buckets, not in ethnicity. Bucket 1. People in work visa categories tied to an employer like H-1B or L-1, where the employer and the job details matter. If there is a wave of compliance checks or site visits, the questions typically revolve around: are you working at the location listed? Are you doing the role described? Are you being paid as stated? And is there real work? Bucket 2. Students on F1, especially those on OPT or STEM OPT, because those categories require ongoing reporting and the job must meet certain requirements. A common issue is a gap in employment, late reporting, a mismatch between the job and field of study, or working for an employer arrangement that is not structured correctly. Bucket 3. People in the middle of a green card process where prior history matters, like earlier periods of unauthorized work, gaps in status, or inconsistent addresses and employment histories between filings. Bucket 4. Visitors on B visas who are repeatedly entering for long periods, or who have patterns that resemble living in the U.S. without the right status. Bucket 5. Anyone connected to a petition that may be linked to suspected fraud, like fake experience letters, questionable consulting arrangements, or petitions filed by entities that are already under investigation. Now, who is likely not affected? If you are maintaining your status, your documents are consistent, and your employer is compliant, routine enforcement waves may not touch you at all. People who are U.S. citizens obviously are not in the immigration status system in the same way, though they can still be questioned at the border like anyone else. Lawful permanent residents generally have strong protections, but they should still be careful with long absences and criminal issues. And importantly, being South Indian or any specific region by itself is not a legal basis for denying an immigration benefit. That does not mean profiling never happens in practice. It means that when you respond, you focus on facts and documents, not panic. Myth versus reality moment. Myth. If you are South Indian, you are automatically on a list. Reality. Without verified official information, we cannot say there is a list based on region. What does exist in many systems are risk flags based on patterns, certain employers, certain types of filings, inconsistent travel, or prior compliance issues. Those patterns can overlap with communities because of where people work and how common certain visa routes are. Another myth: if an officer asks tough questions, you are in trouble. Reality: tough questions are common during periods of increased scrutiny. What matters is whether your answers match your documents and your actual situation. Next, why would an enforcement drive happen at all? The simplest explanation is resources and priorities. Agencies often do targeted pushes when they believe there is a surge in fraud, a backlog that needs triage, or a political directive to focus on compliance. It can also happen because of data. If an agency sees repeated inconsistencies coming from certain types of filings, they may increase audits, site visits, or interviews for those categories. Another factor is timing. After certain filing seasons, like major petition cycles, it is common to see more post-approval compliance activity. And when processing backlogs are high, agencies sometimes use more requests for evidence to shift the burden back to applicants and employers to prove eligibility. Here's a small detail that changes everything. If your case is perfectly legitimate but your paperwork is sloppy, increased enforcement can still create real consequences. That is why the practical steps matter. Let us talk real-world consequences, because this is where people feel the impact. First, travel. If CBP is asking more questions, you may face secondary inspection more often. That can mean delays, device searches under certain circumstances, or requests for proof of ties to your status. For a worker, that may be recent pay stubs, an employment verification letter, the petition receipt or approval notice, and details about where you actually work. For a student, That may be a properly signed I-20, proof of enrollment, and proof of employment and reporting compliance if you are on OPT. Second, work authorization. If USCIS starts issuing more requests for evidence, you may see delays in extensions or changes of status. That can impact start dates, travel plans, and employer onboarding. Third, employer risk. If an employer is not following the terms of filings, employees can get caught in the middle. For example, an H-1B worker moved to a new work site without the right process being updated, or payroll does not match what was filed. Fourth, family impact. Dependents may have their own travel and status questions, and any disruption to the principal applicant can cascade to spouses and kids. Fifth, stress and misinformation. When rumors go viral, people make rushed decisions like canceling travel, quitting jobs, or filing unnecessary applications. Sometimes those decisions create new problems. So what should you do if you are worried? I am going to give you a do this and avoid this checklist. This is not legal advice, but it is a safe, practical way to lower risk and be ready if scrutiny increases. Do this. Confirm your current status basics. Know your status type, your expiration dates, and what document actually controls your stay. For many people, the I-94 record is crucial. Do this. Keep a clean document folder. That includes passport bio page, visa stamp if applicable, I-94, approval notices, I-20 or DS-2019 if applicable, recent pay stubs if you work, an employment verification letter, and your most recent address history. Do this. Make sure your filings match reality. Your employer name, work location, job title, and start date should not contradict what you are actually doing. If there is a mismatch, do not panic, but do not ignore it either. Do this. If you are on OPT or STEM OPT, double-check reporting. Ensure your employer details and address are updated through the proper channels, and keep proof of those updates. Do this. Prepare for travel like it is an interview. If you plan to re-enter, carry supporting documents and be ready to explain your job or program in one clear sentence. Do this. Monitor official sources, not forwarded messages. Watch for updates from USCIS, ICE public press releases, and your school international office if you are a student. Avoid this. Do not assume a viral claim is an official policy. It might be based on isolated incidents. Avoid this. Do not falsify or backfill documents. If there is a problem, fake letters and altered pay statements can create far more serious consequences than the original issue. Avoid this. Do not let an unvetted agent or consultant rush you into filings. If you need help, consider a qualified immigration attorney and verify credentials. Avoid this. Do not ignore mail, emails from your school, or case status updates. Deadlines for RFEs and notices are real, and missing them can end a case. Now let me give you two example scenarios, because this is where the risk feels real. Example scenario 1. An H-1B worker in a consulting setup has been working from a client site, but during the year, the work location quietly changed to a different building, and sometimes they worked from home. A site visit happens, or an audit request comes in. The worker is legitimate and doing real work, but their paperwork still lists the old address. The result is not an instant denial, but it triggers questions, delays, and a scramble for employer letters and client confirmations. The fix is usually documentation and consistency, but the stress is huge and it can interrupt travel plans. The lesson: small location changes can matter when compliance activity rises. Example scenario 2. An F1 student on OPT starts a job quickly after graduation, but forgets to update the employer details on time, and later switches to a new role that is not clearly connected to the degree field. Then they travel and re-enter. At secondary inspection, CBP asks for proof of employment and how the job relates to the program. The student can enter, but only after long delays and tough questions, and they leave feeling like they were targeted. The lesson: the questions usually revolve around compliance, not region. Now, another myth versus reality. Myth: if you get pulled into secondary, you will be deported. Reality: secondary inspection is common and often ends with admission. But it is a sign you should tighten your documentation and be careful, especially if your situation has any complexity. Now let us address the big question directly. Is this routine enforcement or something more targeted? With the information we have, we should treat it as a reported concern and a possible uptick in scrutiny, not as confirmed region-based targeting. It is absolutely possible that certain Indian communities are experiencing more questioning because of where they work, how common certain visa pathways are, and what fraud patterns agencies are investigating. But if anyone tells you it is official that South Indians as a group are being targeted, ask one question: where is the official source? If they cannot show it, do not let it drive a major life decision. Here is what to watch next over the coming weeks. 1. Do you see credible reporting or official releases describing a specific operation name, focus area, or enforcement theme? 2. Do you see a surge in RFEs or interviews in your specific visa category across many unrelated employers? 3. Do schools report more SEVIS-related compliance checks for certain patterns? 4. Do community attorneys and reputable advocacy groups report consistent, verifiable patterns, not just one-off stories? 5. Do travel experiences change widely, such as more requests for pay stubs and employer letters at ports of entry? If these patterns emerge, it does not automatically mean targeting by region, but it does mean you should be more prepared. Before we close, I want to give you one more practical segment. If you are in X group, do Y. If you are on an employer-tied status like H-1B, L-1, or similar, do a quick consistency audit with your employer. Confirm your work location, supervisor, and job duties match what is on file. Keep recent pay stubs and a current employment letter ready. If you are on F1 OPT or STEM OPT, confirm your CVAS reporting is up to date, keep proof of employment and how it relates to your degree, and avoid any arrangement that you cannot clearly document. If you are planning international travel soon, consider postponing non-essential travel if your status situation is messy or your documents are incomplete. If travel is essential, prepare your folder and be ready for questions without volunteering extra information. If you are in the middle of a green card process, keep copies of everything filed, be consistent across forms, and do not ignore requests for evidence or biometrics and interview notices. Final recap: calm and simple. 1. Right now, we do not have verified official information that a new U.S. operation is targeting South Indians as a group, so treat viral claims carefully. 2. Enforcement and compliance activity can increase and still hit certain communities harder because of patterns in jobs and visa routes, not because of ethnicity alone. 3. The biggest risk during heightened scrutiny is inconsistency. Mismatched addresses, unclear job duties, late reporting, or weak documentation. 4. The safest move is preparation. Know your status basics, keep your documents clean, and monitor official sources. 5. Do not panic and do not make irreversible decisions based on rumors. Take smart, calm steps and get qualified help if your case has complications. If you want, comment with your visa category and what situation you are worried about: travel, extension, job change, or student reporting. I will cover the most common scenarios in the next update. Subscribe and turn on notifications so you do not miss new verified updates, especially if guidance changes or we see a confirmed pattern from official sources.